Greetings, everyone. We are back and we want to continue the conversation where we left off. Last time we were talking about the players in the trust. Those are the people who actually create the trust, the people who benefit from the trust, and the people who manage the trust. So the person who creates the trust is the trustor. The person who benefits from the trust is the beneficiary. The person who manages the trust is the trustee. So in summary, we want to give you just a recap of why a trust is important and why you need one. Okay, so within limits, trust can help you achieve several important goals. Management of assets if you are disabled. Management of assets for your children or family in case of your death. Avoidance of probate. Avoidance of creditors. Minimization or eliminate of estate and other transfer taxes. Even if the estate tax is eliminated, the gift tax protection for your loved ones is in place as well. Ownership of your insurance policies and businesses. Trust can even address religious goals. So that's what we talked about last time, and that was a great conversation. This conversation is going to focus on the types of trust. There's so many, and that's why it's important to have a professional. So we have types of trust. We have revocable, irrevocable, and modification of revocable trust. They're all in the California Probate Code. So a revocable trust is created by the trustor, the trustor. That's the person creating the trust during their lifetime. They have the ability to go in and change it. So you may be a beneficiary, and if you don't watch out, you're eliminated out of the trust. So you better be really careful. If somebody puts you in their trust as a beneficiary and you do something to them, they can take you out. You can take out an asset that was in the trust before. Maybe you want to sell that asset off. So that's a revocable trust, meaning you can change it during the trustor's lifetime, during the person who created the trust lifetime. They can change it. That's called a revocable trust. An irrevocable trust is a trust you cannot change. That means someone has passed away and their trust document has to be settled. So we have revocable and irrevocable, and then we have modification of irrevocable trust, which if there's some discrepancy, usually it deals with attorneys or some other professionals. They'll straighten that part out. So we're going to talk about the names of trust. So we know we have the two main types are revocable and irrevocable. Revocable during your lifetime, and it's of course irrevocable. You can't change it after you're dead. So you have revocable and irrevocable trust. So the first trust we're going to talk about is a testamentary. That's created under a will. So you have a will, you have your wishes written down in the will, and you create the trust from the will. So that's a part of it. So it's testamentary. Inter vivos is a living trust. Inter vivos trusts are created during one's lifetime and hopefully funded. Remember we talked about putting the assets in there with all of the assets needed for one's lifetime, but not necessarily. These trusts are typically revocable. That means you can change it. The trustors have the right while they are alive and competent to change the terms of the trust. Often a revocable trust will split into a marital trust and the survivor's trust on the death of the first spouse. The surviving spouse will have the right to amend withdraw or change the terms of the survivor's trust, but the marital trust becomes irrevocable. The revocable trust acts just like a will. When there is a death, the trust becomes irrevocable, which means that it cannot be amended. The only way that you can do that is to give notice to the beneficiaries and then make arguments to the court. Now, the whole purpose, or one of the main purposes, is to make sure you stay out of the court. Who wants to go to court? I don't think anyone wants to get the courts involved, because that's going to take away from the estate, the assets. Going to court costs lots of money. I mean, if you don't mind giving money to attorneys, courts, and all of the fees that come with that, then be my guest. But that's one of the main purposes, is to protect yourself from having to pay all those high probate court fees. There's a spendthrift. It deals with someone who would dispose of the assets. Grandmother knows that her grandson is not a good manager of money, so a trust is set up to protect the assets from being disposed of frivolously. So someone who can't manage money, you may have an only child or an only grandchild, and you know that they don't handle money well. So you can create a trust for them. It's called a spendthrift trust. Special needs trust. We kind of hit on that last time. And so many people are being born with autism and other developmental disabilities that I've seen so many special needs trusts. Spendthrift as well, but special needs is a growing aspect of the trust business. And it's created for a child with special needs. There are two types of special needs trust. The first one is a litigation trust. It's the one where the corpus of the trust comes from a court settlement, such as settlement against a doctor. So it's from a lawsuit. A litigation and third-party trust are becoming more prevalent. Litigation in California, we are one of the most litigious states. I think we're number one. Yeah, we will sue you in a minute. I mean, yeah. So, and then the second part of a special needs trust, or the second most popular part, is a third-party trust. Anyone can decide that they want to leave money to a disabled child. They want to make sure the child is entitled to all of the public funds first they can get, but they still can provide some of the money to improve the child's life. I was involved in a special needs trust a couple of times, and how that works is when you have special needs, you're entitled to public benefits, even if you're wealthy. So you create this trust, a special needs trust, for any extras that they may be entitled to, or they may not be entitled to, because the government is bare minimum. So they may want a wheelchair with all of the works on it. They may want a certain type of bed. They may want other upgrades to their lifestyle that they can't get through public assistance. So you can create a third-party trust for your special needs, family member, friend, or whoever. There's also an education trust. So in your regular trust, you can leave money for the education of your grandchildren, for friends, family, and you can put that money in an education trust. There's a charitable trust. I have a case now with a charitable trust, and one of my clients, she's going to leave a large portion of her assets, which is large, to her church. So that's a charitable trust. So in summary, this short gives you the names and types of the most likely trust that you're going to encounter. It's very important that, again, you use an attorney to actually create the trust. Someone who specializes in probate, estate planning, and trust. That's who you want to get counseling from, so that you can make sure that everything is done properly to keep you out of the probate courts. So we talked about the most popular type of trust. We know what a trust is. We know how to fund the trust. We know the importance of making sure that all of our assets are funded in the trust. And we know some of the types of trust there are. We know that the trust has so many protections for us that you can feel comfortable and you can feel safe that in the event something happens, your wishes will be granted. Your money will be spent the way you want it to be spent. I really like thinking that you're speaking beyond the grave. I like the fact that you're still in control of what you worked really hard for. You're making the decisions before anything happens, and you're saying, if something does happen, just in case, these are the things that I want. This is what I want to happen. This is how I want it to happen. And during your life, I mean, you can save a lot of money. Transfer taxes, if you're selling property, all of those things can go in your trust. So we kind of talked about that. And the next time we're going to continue the conversation about trust. We're not quite done yet. And we're going to keep going. And then we're going to talk about probate courts. Thank you all again for taking out a little bit of your time to listen to this very important subject that we all should prepare ourselves. We should prepare ourselves just in case something does happen, something that we're not thinking about, but accidents happen, things happen, whether you're young or whether you're old. If you have assets, it's very important. If you don't have assets, it's still important to make sure that your wishes are known through an advanced health care directive, your medical directive. Those things have to be written down. You have to be able to protect yourself in the event of an emergency or the event of death. I want to thank you again for listening, and I look forward to bringing you more information about trust, and then we're going to go into the courts and the probate. So leave your comments in the comment section, ask questions, and let me know what you think. Thank you so much again. I look forward to coming back and giving you more of what you bargained for. That's great information. That's timely information. That's important information to help you prepare for any type of emergency. So the question now is, are you prepared?